Hi guys, I'm Tony Doherty from No Borders Radio. This is Cleveland. He's part of the response team, and we've been up to Leicester County Court. So Cleveland can get a judgment. Do you want to explain a little bit about what's just gone off?
So we were in court today to get a decision on the ability to appeal against the judge's order of 10th of July 2014. A decision which was not granted, despite 160 pages of documented evidence put into the court showing the complete fraud committed by NREM, and that's not talking about the fraud guys that we know about, as in the collateralised mortgage, which I do have, by the way. We were talking about fraud of NREM paying extra money onto my loan agreement for paying off one of my creditors, which there are rules set in place under law that prohibit them from doing that. The judge has completely ignored basically all the evidence I submitted, even something that was spotted late, and this is something to remind you folks about there. It doesn't matter how late in the day you spot a rule breach by whether the complainant or the court, you can enter it at any point. A perfect example of this is I'm standing in the court today giving information about the fraudulent deed that the mortgage company entered into the particulars of claim. You see, if you're smart enough, you're going to take £7 out your pocket, run to the land registry, and you're going to get yourself a copy of your deed. We already have a test case in the High Court that has voided a mortgage because the deed wasn't signed. In my case, the claimants entered a copy of the certified deed showing a signature from the bank, but then they entered a second copy of the deed later on which didn't show a signature of the bank.
But the judge was quite adamant that there is two signatures on some piece of paper somewhere, but it's not at the land registry where it should be.
And even when I produced the copy of the deed from the land registry showing that the bank had not signed it before they'd lodged it at the land registry, which is a requirement of the 1925 Mortgage Act, she weren't having it. As my esteemed colleague has just told you, she was quite happy because one document had been entered into the bundle, signed by both parties. She's fine with that.
Even though it was fraudulent?
Even though there isn't a loan agreement between us. There is not one loan agreement between us. The bank haven't got a loan agreement between me. When asked for one, they sent me a letter stating they don't have a copy of my loan agreement and sent me a copy of an application. An application I did with the mortgage broker in 2002.
How can they get away with this?
Well,
where does she... I mean, from the feeling that we got the moment, there was a little bit of... Hang on, who are these people? And the reason we didn't stand up is, well, why would you? None of us stood up in court at the beginning. Yeah.
Because we're not in a court. Despite the judge took quite a few minutes to try and persuade everyone in court that it is not an administrative hearing, and I would dispute every aspect of that, because if I was in a court, my documents would have been heard.
Yes.
The simple fact, they didn't take any notice of my documents, even though they said they did. The simple fact they didn't shows us we were in an administrative court. And at the same time, I'm in a court with one judge hearing what is a complex case. How is that fair? Especially as that judge knows that I have filed a complaint about her to the court.
This is something that came up in one of your videos I was watching. Well, in fact, a video I did the other week, about a month ago, up at Nottingham. And you were saying in there, but how do we actually know who these judges are?
Well, we don't, because
of the names.
Because of the name. The judge today was appearing under the name of Her Honour Judge Hampton. Problem is, I've sat in front of Judge Hampton 3 times, and that wasn't her. It weren't her. 3 times. I've said this before. Tom's got his petition on at the moment for, getting the judges to obey to CPR, and I expressly asked him a month ago if he would add on that a notice, a badge identifying who each judge is, with a picture. We need this, and we need people to start remembering names of judges and faces of judges, so that the next time somebody mentions a name, somebody goes, oh yes, I sat in front of her. You can all compare. of what these people look like. Because I still think, let's put it this way, after I'd given my argument, the claimants have given their argument, the judge basically went into giving a decision. Now, considering the length of time that we're in there, putting all these arguments over, that decision was bloody quick, because we know she already wrote. She had the decision planned before we even walked into court. That is a fact. That decision was already there. Now, I will say another thing. Anyone who's defending against anyone as a defendant in court, don't go to small claims court, lower court, unless you're prepared to go all the fucking way. If you're not going to go all the way to the High Court, and by that I mean, like I've done today, appeal, I'm already ready to appeal to the Court of Appeal, and when that's over, I'll be putting in a claim if I don't get justice at the Court of Appeal. But what I'm saying to you guys is...
That was something else that I noticed when you said, well, where's my remedy?
No,
she sort of brushed it away. Like, well,
brushed away, no remedy.
Yeah.
No remedy at all. You see, we're dealing with a company who made a mistake on just statements alone in 2012. Just the statements they sent out to their customers. And that mistake cost NRAM £40 million in compensation that they had to pay out to their customers. But today, they didn't make a mistake, they made an error.
Yes.
That's another word you need to look out for, ladies and gentlemen. The use of the word error. You can go through how many dictionaries you want, and the uses for the word error will go on 2 pages. There's dishonest, well, we know there's a dishonest error, there's an honest error, there's an innocent error, negligent error, and the list goes on. What these, and especially if you look at my last hearing on the 10th of July, and Judge Atkinson didn't want me to use the terminology of fraud, misrepresentation.
Yeah, she wouldn't allow that today either.
No, she didn't want it today, because these are covered under the 2006 Fraud Act, Section 2, clearly states false representation is a fraudulent act. And that's what went on in this case. They fraudulently represented the case to hide this, with intent to deceive the court. But the court doesn't see it that way. Not at all.
No.
The court sees it as an honest error. But an honest error doesn't happen 2 years after the fact.
No. So what do you do next?
What I do next now is, because I've structured this thing from the start, knowing I was going to go all the way, by Monday I will be filing an appeal to the Court of Appeal. So I'll be waiting to get confirmation on that, and as soon as that's over, whichever way it goes, if it goes against me, a claim will be filed. Now at the moment we're still having trouble getting our claims in under the Magna Carta, which states that we do not have to pay to take someone to court. Chapter 40 of Magna Carta states we will sell and deny justice to no one. That clearly tells you that we shouldn't have to pay to take someone to court. But in this instance, because we're talking about £14,000, it's going to cost me about £350 to £400 to submit a claim to Queen's Bench. Now, let's understand what Queen's Bench deals with, people. It deals with breach of contract, it deals with negligence, it deals with tort, and that is exactly how you've got to structure your particulars of claim. The last time I tried it, I put down fraud and I listed all the things that they did wrong. That was rejected. Now, this time when I do it, I'm going to put down they breached the contract and show where. They were negligent in handling my account and show where. And then they also caused me a tort and I will show where. And we'll see how we go with that one. But as it's a paid case this time, when we go to Queen's Bench, I don't think they can reject it like they did my last one.
We'll have to see if we can get your whip round. Well, Paul's bought the beer.
But be strong.
Paul.
Thanks, Paul, for the beer. But be strong, folks. This fight is nowhere near over. No. And we all have to be strong. We all must take people with us. I thank everyone that came to court today, because every one of them was a witness to what's gone on, and it's great, because if she'd have done major harm or major wrong in there, which she has to an extent, she hasn't really broke any judicial conduct rules, so I can't actually complain about her on that. If she had, I had nearly 12 people in court that could have all filed up a complaint. Even if it's one complaint is better than none. And remember, you start with the OJC 10, then you move up to the what you call it, the Chief Justice, Lord Chief Justice.
Yeah.
Then you move up to a complaint to the Privy. Then you move up to a judicial review. Then you can complain to the Lord Chief Chancellor, and then I forgot where you can go after that. I think that's about your limit.
Yeah, it is.
No, Privy Council. Privy Council.
Privy Council.
It's still in there. It's a complaint that's in there. And the more complaints we get in about judges, I think the less problems we're going to have. So our complaint is their restraint. Let's use it.
So thank you for this, my friend.
Thank you very much, sir.
And I'll get this up on YouTube tonight.
Brilliant.
And I'm going to lift the audio and chuck that on my show next week. So it's No Borders Radio. All right, you take care, guys. We'll catch you in a bit.
Peace. Cheers, brother.